Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients in the Dallas and Fort Worth area. Today's quick video is going to answer the question, what is a prove-up or what is a prove-up hearing? To answer that question, I'll first give you a brief answer of what a prove-up hearing is. Second, we'll talk about some common types of prove-up hearings you may experience. And then third, we'll talk about the typical format and what to expect at a prove-up hearing. Before launching into the answer, let me point out that if you are working with an attorney, you should really be talking to your attorney about what to expect at your specific prove-up hearing. Your attorney is preparing evidence and testimony and other documents for your prove-up hearing, and so your attorney is going to know best what to expect at your hearing and how to help you prepare for it. So definitely do not substitute this general information for the specific help that your attorney can provide. After all, that is what you're paying him or her to provide you. But that said, let's move into a basic answer of what a prove-up hearing is. An a prove-up hearing is a brief hearing to present testimony or other evidence to the judge on an uncontested issue or an agreement between the parties. Now, that may sound an awful lot like any kind of hearing or trial in front of the court, because testimony or evidence is always or almost always going to be provided to the court in a hearing. The difference is a prove-up hearing is a hearing where evidence is presented, but the parties are in agreement, or there's at least no contest between the parties as far as resolving the case. But for various reasons, evidence needs to be provided to the court on whatever claims have been provided before the court can grant the requested relief. So that's the big difference. There's not a dispute between the parties at this point, or there's not a dispute in front of the court between the parties. But evidence still needs to be put on, and there are various reasons why evidence may be put on or needs to be put on, depending upon the specific kind of lawsuit. But that's delving a little too deep for what we need to do. I just think it's important to understand that a prove-up hearing only relates to cases where there's no longer a dispute between the parties or a legal dispute between the parties. So some common types of prove-up hearings you might experience, there's really three you may come across. First is in family law. You can have all kinds of prove-up hearings. The most common is probably for an uncontested divorce, where the parties have reached an agreement and they go before the court and present very scant testimony to the court that allows the judge to grant the divorce decree. Under the Texas Family Code, the court has to receive certain types of evidence for most orders under the Family Code before the court can grant any kind of relief. In addition to uncontested divorces, a prove-up hearing may be necessary in other types of agreed or settled cases, such as modifications of custody or modifications of child support. Enforcement type hearings can also be resolved by a prove-up hearing. But by and large, if you're handling a divorce where the parties are in agreement, there will be some type of prove-up hearing to resolve the divorce. Second, in a case where there's a default in a civil lawsuit, the plaintiff who is seeking the default order may have to put on evidence depending upon the types of claims and what evidence has been provided to the court already. But the plaintiff may have to put on a prove-up hearing and just put on testimony or present other evidence that demonstrates a claim so that the court can grant the default. And just as an aside, a default is when the plaintiff files a suit, serves the defendant, and the defendant fails to respond to the suit within the required time. When that happens, the plaintiff is allowed to go to the court and ask the court to grant a default on the claims presented in the petition. Really, it gets too deep talking about what kinds of evidence or what kinds of claims are necessary for that, but a default may require a prove-up hearing before the court can grant the plaintiff all of the relief requested. And third, and this is the least common of the three, if there's a claim involving a child, the court is required to appoint a guardian ad litem for the child, and for the guardian ad litem to investigate and participate in any kind of settlement. And before the parties can agree to a settlement involving the child, evidence has to be put on before the court proving up the settlement and that the settlement is fair for the child. And then the court has an opportunity to accept or reject that settlement on behalf of the child. This is different from a normal settlement agreement between parties that are adults. When it comes to adults, there usually isn't a prove-up hearing required. The parties just sign the settlement agreement and agree to dismiss the lawsuit. There are some other prove-up hearings that may be necessary, but by and large, these are the three most common that people will come across, and of all of them, those family law situations are the most common. So let's talk about what happens at a prove-up hearing. What actually happens at a prove-up hearing will differ depending upon the type of lawsuit that's involved and what kind of claims are involved. As you can imagine, the type of evidence you're going to put on in a divorce is going to be very different from the evidence you put on in a car wreck type case. The judge isn't going to care when you were married in a car wreck, probably. But in a divorce, that's a necessary piece of information. So the particular type of testimony or evidence put on is going to be specific to the case, but the format generally is going to be the same. Typically, only one party will appear for the prove-up, although sometimes both parties appear, and typically the one party that shows up is going to be the one putting on all the testimony or evidence. Occasionally, if both parties have shown up, there may be some evidence put on by both sides or some questioning from one side to the other. But in the vast majority of cases, you're just going to have one party show up and put on evidence. That party may or may not be represented by an attorney. If an attorney is present, the attorney usually asks the party questions to elicit the testimony that's necessary for the prove-up hearing. If you show up pro se without an attorney, then you're probably going to have a script prepared of all of the information that you need to provide the judge in your testimony so the judge can grant your order. A prove-up hearing is usually just the party's testimony, although in civil lawsuits, it may be necessary on a default to present other types of evidence, to present witnesses, and essentially put on an entire case that you would in trial, but without the presence of the other party putting on evidence or attacking your case. An important thing to know about a prove-up hearing is that all of the rules of procedure and all the rules of evidence still apply to the prove-up hearing. However, because there's no opposing party there to make objections or dispute the admissibility of evidence, you can really get away with presenting evidence in a manner that you couldn't do at a contested hearing or trial. A good example of this is putting on hearsay evidence. Sometimes you can slip that through and the judge doesn't care because nobody is opposing it. But often if you have an attorney and the party together, the attorney will just ask leading questions of the party because it's easier to get the party to give the court the information that it needs in order to grant the order. But if you're putting on other types of evidence, such as documents, there are evidentiary rules that have to be followed, and the judge can deny your evidence if it's not presented in the right manner. Now, again, this is really an uncommon situation. For family law, it's usually just one person telling the judge about the situation and that an agreement has been reached. But in a default or in those minor, the child settlements, there may be other documents or other witnesses that are put forward, and these parties or these pieces of evidence still must follow the rules of evidence as far as admitting their testimony or the documents or whatever the other evidence is. But by and large, if you're going in by yourself or something like a family law case, this is probably not something that you need to break down and try to learn before your prove up. So the only thing that's really left to talk about, I think, without getting too deep into specifics of any one type of proof up hearing, is what kind of testimony or evidence is going to be put on. I can't speak to any particular type of case or type of claim because I think that gets a little too deep. But generally, you're going to want to put on evidence, even if it's just your testimony, that speaks to all of the elements of whatever claims or whatever types of relief you've requested, plus any information that may be important to go into the record right at that time. So, for example, in a divorce, you're going to need to put on evidence about the parties, the marriage, the kids, the property, and some other things that go into it. All of this evidence has to be on the record for the court to grant that order. And so you need to know what specific elements or what specific pieces of information the court needs to hear. And that's going to depend upon what type of claim you have and what kind of relief you're asking the court to present. So you need to be prepared to provide all of that information at the hearing. The good news is those prove-up hearings are usually pretty relaxed, and oftentimes the judge will help you along if you're not sure or you forget a piece of information. The judge may ask some questions to help you get that information out there. But do be prepared to provide the information as best as you can, because the judge isn't required to help you out, and the judge may choose not to help you out. And if you fail to put on sufficient amount of information or the right kind of testimony, the judge may decline your requested relief or your proposed order, and you can kind of be stuck spinning your wheels. So naturally, as you might expect, I'm going to tell you that you're probably better off hiring an attorney to help you out with your claims. But if you're this far, maybe you can successfully do it yourself. But that's basically it. That's what a prove-up hearing is. That's where you're likely to find prove-up hearings in Texas. I hope this video was helpful. If you're looking for more information about family law or employment law or other types of personal litigation, visit my website. The link will be in the text below the video. Anyway, again, hope this was helpful. See you next video.